All right, good morning, everyone. It's Monday, September 20th, 9:30, and this is the Planning, Housing, and Economic Development Committee, and we're convening to consider legislation that Councilmember Jawando has introduced, Bill 3021, which is restrictions on rental increases during emergencies, basically the COVID pandemic. We have Christine Wellens, who is the council attorney who has drafted this, and we're joined by DHCA Director Nagam, Mr. Demaray, Rosa McCrae Moody, and you can start with comments from colleagues, and we can go to DHCA, and then we can walk through the packet. So we want to start with Mr. Jawando.
Thank you, Chairman Reamer. Good morning, everybody. So we've, I discussed this a bit when we had the public hearing and we introduced the bill. But this, just for the millions watching at home, first time saying it this since we've been back, this would extend the cap on rental increases that we put in place. Bill I introduced and we passed unanimously last year during the pandemic, to hold rents to the voluntary rent increase guidelines. And that was 2.6, I believe, last year. It was 1.4 this year. It's tied to the rental part of the consumer price index, basically inflation. And we know that we're still in the midst of the pandemic. The numbers show it. The talk about the vaccinations as we get back to school, we're eager to get more people vaccinated, including our young people. Some good news on Pfizer's front. Hopefully we can get emergency authorization there. But the economic fallout is still with us and will be long lasting. We know that many renters are behind. We've got close to 15,000 people who have applied for rental assistance. We know, however, that 2/3 of the people who are facing eviction haven't applied. And so we know that there's still work to do to get the information out there. We're going to probably need to appropriate more money on that side. There's not enough. We don't have enough money, with the average award being $10,000 to take care of all the people who've already applied, assuming that they were deemed valid and needed applications. So we have a serious issue, but we're doing a lot on that front to try to provide tenants with rental support. That is landlord support, and it's the right thing to do. And we put almost $60 million into that, with probably more to come. This is a very measured protection, one that is actually a little less than some of our neighbors. Prince George's County and DC, for example, did not allow any rent increase, and those protections are still in place, not set to expire like ours is, just in about a little under 2 months at this point. And so this would extend that protection, that cap, to the voluntary rent guidelines until we get to August of 2022. And really importantly, it would also prohibit the accrual of late fees during that same period. We know if you're behind and late fees start to accrue, you get more behind, and it puts you in an even less stable situation. The last thing we want, as the variants continue to come and we're trying to get people vaccinated, is to put people in an unstable living condition, risking their health, risking their students' success as far as displacement while they're in school, and risking eviction. So I think this is a measured approach. I hope that we can extend this. And the other thing is that there's really no other protection there. The CDC eviction moratorium was thrown out by the Supreme Court. And the governor has let expire both his eviction moratorium and the state of emergency that this original bill was tied to. So folks are not, there's no protection at this point. And so we really need to do what we can at the county level to make sure people are stable and safe in their homes. So I appreciate the opportunity to set that up, and I hope that we can pass this and get it done in short order. Thank you, Mr. Chairman.
Thank you. I just want to add here, not sure, Councilman Friesen, if you'd like to make remarks yet, but that, as Councilmember Jawando said, when we passed our provision during the peak of the pandemic, it was more balanced than other jurisdictions in the area that kept the increase to zero. And I think we recognized that property owners were going to be facing some tenants that were defaulting and most tenants that were making payments, and they were going to need to absorb some of that impact. And so, those who hadn't faced that economic impact could potentially accept an inflationary increase, while those, who can would not. And so we made the decision to allow that inflationary increase. And I think that was it was a balanced decision that hopefully has allowed this sector to absorb some of this economic challenge a little better. So I just think that's worth noting. Secondly, we can get an update on the disbursement of the rental assistance, but my understanding from council staff is that we'll hear from DHCA, but that we're basically on track to meet our goal of 2/3 disbursement by the end of September. So we are applying as much assistance as we have and as we can now, and indeed we might need more, to help offset the impact. There is an amendment that I will propose in a bit around fees. I think that it's true we don't want someone who can't pay rent to have an accrual of fees. What's the point of that? But I also think it's important that we tailor that and target it to those for whom they're experiencing a COVID impact, and not necessarily allow for that across the board for all renters. I should say, to disclose, that I am a property owner. I have 2 units that we rent, but I don't think that my personal interests are different here than my interest as a parent in school policy, having 2 kids in the schools, or wanting to be safe and doing police policy. I think I have a very general interest here that relates to the public. So in any event, I will, Councilmember Friedson, if you'd like to say anything, otherwise we'll move to DHCA for an update from them.
We can move to the bill. I mean, I have a proposed amendment as well, but we can wait until we discuss the content of the bill before discussing that. Thanks.
Sure. DHCA, anything you'd like to say at this time?
Good morning, everyone. Asim Nigam, Director, DHCA. And as Councilmember Will was mentioning, the pandemic is still ongoing, and our economic recovery is going to take longer than the health recovery. We have several tenants who either lost their jobs or have seen their hours cut. So they're struggling to make whatever payments they can at this point. And what this bill does is, and for those folks who are watching it this morning, this is simply a temporary measure. We are not saying to put this bill in place on a permanent basis per se. So what we're saying is what this bill does is puts a limit on the rent increases to water rent guidelines, which is currently at 1.4% for the next 1 year. This is not on a permanent basis. So which will allow our tenants to basically stand up on their feet and give them some certainty that they won't be facing high rent increases while the economy is recovering and they're taking care of their families. So we think that this bill is reasonable, and the county executive supports this bill. And as Chairman Reamer was mentioning about rent relief payments, it is Department of Health and Human Services who is administering this program based on conversation with them, and we are collaborating with HHS. They have received 7,000 or 8,000 unique applications. They are going through those applications as fast as they can. And what we heard recently was that they are on track to either spend or commit 65% of $58 million by the end of September. So if there are tenants out there who have not applied, there's plenty of money. Even beyond this $58 million, there's additional money and from the ARPA funds for rental assistance. So the monies are there. So we are encouraging our tenants to seek assistance, financial assistance, legal assistance, or any other services where our service providers, whether it's Renters Alliance, CASA, LEDC, HEP can provide, including Maryland Legal Aid, homeless person representation project. So we have all the resources. So please reach out to us or to HHS for any rent relief payments. With that, I'm giving back to Chairman Remartio.
All right. Okay, Christine.
Good morning, Mr. Chair and council members. Thank you. So I would just add that in terms of specific dates, so just to reiterate for everyone, the governor's state of emergency expired on August 15th, 2021. And under the law, as it's currently written, the relief from rent increases above the rent guidelines would expire on November 15th. So this bill would extend that limitation until August 15th, 2022. And then in addition, put in a restriction against late fees for that same time period. The staff memorandum provides you with some information on how some other jurisdictions have approached this issue, and Councilmember Giwando spoke to that as well. In addition, there's some brief in items 2 and 3 of the staff memorandum, there's some brief summary of the economic impact statement and racial impact statements, which I won't reiterate, but essentially just, emphasizes that the economic impacts would be uneven and that disproportionately, poorer residents and Black and Latino residents would disproportionately benefit because they're experiencing the most housing insecurity in the county. And I should also mention, we do have representatives both from CASA and also from AOBA to answer any questions that the committee members may have. In terms of potential amendments, you'll see at item 4, this is the bottom of page 4 of the staff memorandum. There are essentially, I would characterize them as housekeeping amendments. When this bill was introduced, the governor's state of emergency was still in effect, but of course, as we know, it has since expired. And so the amendments that are reflected in the bill attached to the staff packet would take into account the fact that we know specific dates now. And so bring a little more clarity to that. There are no intended substantive changes there. So that's one set of amendments for the committee's consideration before you get into the more substantive amendments that council members might want to bring. And also just to apologize, in the recommendation at the bottom of item 4, there's a typo. It says if the council decides to enact Bill 2020, that should be Bill 3021. Then staff would recommend those clarifying amendments that I just mentioned. Thank you.
Thank you. Ashanti Martinez, if you'd like to turn your camera on, you're certainly invited. Why don't we just do the staff technical amendment without objection at the moment? Without objection. Okay, hearing no objection. All right. Great. Why don't we proceed then to amendments that council members want to add? Okay, so I guess I'll start. Christine, can you point us to the page in the packet, and then we'll walk through.
Yes, so it's page B2. Actually, I think it should be B1, but I apologize, I mismarked it. So it's the very last page in the packet. It is designated B2. And this is the potential amendment by Councilmember Reamer, Chair Reamer. I can share my screen if you'd like it in front of you.
Well, it is in the packet on the last page. So I'll just make an introductory comment and then I'll ask you to read it. So again, as I said, understand the need for us to avoid those who are facing eviction, to be racking up fees. What's the point of that? We need to get rental assistance to those individuals and try to close those cases out. So agree about the importance of that, but also just a bit concerned that the timely payment of rent is essential for everybody. The whole rental market needs, there's a lot of financing tied to the timely payment of rent. And so we don't want a general message out there that, for the next year, there will be no late fees if you don't pay your rent on time. That, you need to have a comment, you need to have a correlation with the COVID impact and need. And in that case, we would be, accommodating. So the amendment that I am recommending it basically builds on the rental assistance framework and that the county has been using, which, the kind of criteria, and also ask tenants to make best efforts to get rental assistance. It is concerning that, a number of individuals who are tenants who are facing COVID impact and are not able to pay rent or are not paying rent have not applied for assistance, and they need to. We have funding that we can bring to help that tenant avoid, a very consequential debt that they'll carry around, and that'll impact their future rental viability, and of course help the property owner to ensure that their building is funded and they can maintain it. So we want people to get assistance, and so just again, urging and requiring people to make an effort to get assistance, and then they'll certify their COVID impact. So Christine, if you could please read us the amendment, and then Councilmember Jawando has a comment.
Yes, thank you. So this amendment would amend lines 30 to 33 of the bill, and I will read what subsection D would be with these amendments. Late fees when prohibited. A landlord must not charge a fee to a tenant for the non-payment or late payment of rent due during the emergency or due between the expiration of the emergency and August 15th, 2022, if the renter submits to the landlord a declaration under penalty of perjury indicating the renter has used best efforts to obtain all available government assistance for rent and has suffered a financial hardship directly or indirectly related to the COVID-19 pandemic.
All right, Councilmember Jawando.
Thank you, Chair Reamer. I wanted to point out a couple of things. We tried to, when we introduced this bill, last year, I tried to put an amendment in that would not allow the accrual of late fees. And just to give context for folks, as we've said, the last thing we want is piling up of rent. If you had a $50 late fee for the last 20 months since March of 2020, kind of the beginning of the pandemic, that's $1,000 that's been added to, and late fees obviously vary, but just to give context, that's a significant amount of money that has been added in addition to what you already owe. In some cases, somewhere between 5 and 10% potentially of what you want owed for the whole year. And so there are already people, this bill does not go retroactive. I just wanted to make that point, that late fees that have been paid or been levied would not have to be rescinded. This would just be going forward. And so that's the context we're in. I mentioned at the beginning that, unfortunately, which is the reason we need a lot of education and continued education and help with our partners in DHCA and DHHS, as I know everyone's working hard, but we're going to need to ramp it up, is that, 2/3 of the people currently facing eviction have not applied for any relief. And one of the things when you turn this into something that you have to request or send or certify, that there's obviously a risk that people don't assert their right, that have had COVID economic impact, that don't get the information. So we're going to have to really step up and make that happen. But all that being said, I do think this is a reasonable compromise, and it's better to provide some protection as far as late fees as far as not having any, which is what we have now. And so I appreciate Councilmember Raymer putting it forward. And for those reasons, I'll support the amendment. Thank you.
Appreciate that. Thank you. Councilmember Friedson.
Yeah, I appreciate it. I have an amendment also that will address this. So I appreciate where this is tempting to go. I'm going to vote against it only because I would prefer to go in the route of the amendment that I'm going to be proposing, which includes late fees, but also addresses the overarching issues. But I'll talk about that amendment after we dispose of this one.
Okay. All right. Well, since this is a late breaking amendment, I will invite a representative from our AOBA and CASA to make a comment on the late fee issue. And then we'll move on to the next amendment. So why don't we start with you, Ms. Whiteman.
Sure. Thank you, Councilmember. First, I want to thank you for having us today. I think, certainly I know that we're all in agreement that we are doing all that we can and should do more to help those residents impacted by COVID. And that's why AOBA and its membership has been actively engaged with HHS and other partners on helping to accelerate the disbursement of COVID rent relief funds. We do think that the spirit of this amendment and the one that will be proposed by Councilmember Friedson is going in the right direction in terms of targeting relief for those who have been impacted by COVID. We do have some concerns with this specific language. I think, what does best efforts mean? And maybe the council should consider, for example, a standard or a test that's known to both residents and housing providers, such as eligibility requirements under the existing COVID rent relief program, or a similar program that's and also importantly known to the agencies, either like NPD sort of threshold that's known to DHCD, or preferably the COVID-19 rent relief standard that's known to HHS. That's something that's known to residents, and that's also known to the agency, and it could be a very determinable standard for saying this individual qualifies for limitations on rent increases or limitations on late fees. And let me just briefly, because I don't want to take up all the time, I know it's important for you to hear from the housing providers on this call too, because I know there are other stakeholders that will have the time to speak.
Okay. We're expecting your voice to represent the housing providers.
Sure. I mean, I think, Ashley Powell from Southern Management is on, and Luke Lanciano is on the call as well. And to one of the points that was made about best efforts, for example, the DC law, there are concerns there, but it does require the tenant to file an application for stay DC. And so that is an important step. And that's important to note, given that the biggest hurdle, as we understand it from HHS, is tenants not completing the application or filing the application. And certainly that hasn't been a lack of effort. I know Council's been involved, Renters Alliance has been involved, HHS, everybody's been trying to do their best to get word out, to get tenants to apply for the money that's available. So I think in terms of the best efforts language, I think that's something to consider. The standard on the COVID-19 rent relief program is very clear. It's also been clearly communicated to residents. I think the focus is really on getting residents to actually apply and receive the available funds. And certainly, finally, and I know this is going to be addressed further, focusing the bill on those who really need it. We don't want to be having a discussions about those who, as we know, that can pay rent or that would be incentivized not to pay rent because of late fees. Everyone on this call and others have been singularly focused on how do we get relief, or how do we continue to get relief to those impacted by COVID-19.
Thank you. So we use the language of best efforts from the CDC moratorium language. So that's where we found that. And as for the correlation between rental assistance guidelines and eligibility for this, that is our intent. So Christine, can I just ask you to clarify, the draft of it has the renter submitting to the landlord an affidavit essentially that they have used best efforts, which would need to be verifiable, and has suffered a financial hardship. That's intended to reflect the criteria used for rental assistance. Christine, can you just comment a bit here on for the legislative record?
Sure. I think that, as you stated, Councilmember Reamer, we used language from the CDC moratorium that was in place prior to the Supreme Court striking it down, and that used the best efforts language. So we could flesh that out with the additional, looking at HHS's website, the additional specific criteria that about gross household income, about having been a resident since August 2020 and owing $1,000 or more to current landlords. Is that the specificity folks are looking for here, to add those additional specific criteria?
Yeah, if I could jump in just quickly, just as be of assistance, I think that's right, and I know DHCA has their hand up. But if you look at the COVID, there's two things. There's that certification you were just mentioning, and then there's the COVID impact certification for the rental relief, which basically says, please explain in detail your household's financial situation has changed, both directly or indirectly, to the pandemic. It must be clearly detailed the financial hardship. General statements as I lost my job will not be accepted. This is the form, looking at the form that you have to fill out. So I would assume that DHCA would work, be using a similar form, but we probably want to hear from them. But I think
thank you, Councilor. I just think that the amendment is just not clear on that, and Councilor Reed also mentioned a certification, and I don't read the language as clearly saying that will be part of the process, and so that raises some concerns.
So if I can interject for a second, thank you very much, Councilor Giovanni. In terms of late fees, our challenge has been to reach out to the tenants. DHCA has taken all stops out. In terms of reaching out to the tenants, we have distributed 60,000 flyers. We have done collaboration with service organizations, with community partners, with tenant organizations, with property managers, with regional service center directors. So our challenge in this, amendment would be, and I'll come to the main point here, that we do not know whether or not the tenants know about the rental assistance, and we know that the tenants have not applied for the rental assistance. We know that for sure. So to put the burden onto the tenants to say that they will get this relief if they have applied for the rental assistance, I think is going to be a pretty tall order for us. What we would suggest is that, in the amendment, we don't put the burden of proof on the tenant per se. We should ask the landlord to provide some sort of declaration form to the tenant, but then any amendment should not be predicated on the tenant applying for the funds per se. Because we know for a fact that we have not been able to reach out to all of the tenants who may be behind on the rent despite our best efforts over the past several months. And we know for a fact that tenants who are behind on the rent, they have not applied for the rental assistance. And we know for the fact that there are certain tenants who may not even understand what the process is, how to get to HHS to apply for the funds. So this will be pretty tall order for our tenants to overcome if we put, this kind of a condition before they get relief from the late fees or any, back due rent or something. So from the administration's point of view, this is something which we will not be supporting if in the language it says that the tenant has to demonstrate that they have applied for the rental assistance. Thank you.
You would not support. How will you determine what best efforts are if a person hasn't applied?
What we are saying is the landlord should provide a form, some kind of declaration form, which Rosie and we talked about. We can come up with. We can reach out to the landlords. The landlords should provide that form to the tenants who owe them back due rent and who owe them late fees. Then the tenants give them that certification.
I see what you're saying. So you're saying flip the. I'm sorry. Since I asked the question, we're flipping the burden of proof. So if you want to charge a late fee, you need to get this form to your tenant to find out if they had a COVID impact. I think is what he's saying, as opposed to what it could be. What it seems to be now is that if you don't want late fees charged as the tenant, it's on you to apply and know that you have that right and figure it out, which I do think it's just a fact that if we do it that way, you put it on the tenant, many will just not even know they have the right and will not fill out the form. And that is a problem. But so I think that's what he's saying, Hans. It's your amendment, but I just wanted to say, I think he's saying create a form that they could help with that would go out and saying late fees are prohibited. But if for folks who have a COVID impact and you landlord, you have an affirmative responsibility similar to what we did with the metering thing, send something to the resident to say, we're going to charge you a late fee unless you had a COVID impact, fill this out. Is that what you're saying?
Yeah, okay. Exactly. Thank you.
Okay. So I guess that is an administrative process, to simplify or ensure notification to the tenant. Rather than as written, a late fee would be assessed, but then the tenant would contest it by demonstrating that they have made best efforts, which I don't know how they would show that if they haven't applied. I don't know. To me, it seems you would have a hard time showing an effort to get rental assistance if you haven't applied. And so they would, I think what I'm understanding is they would still have to show that, Director Nigam, like they would still have to show that they have made an effort, but their notification comes from the landlord with a form so that it's a streamlined way for them to understand their rights and to exercise their rights. But the actual right would still be the same, that they have to show COVID impact and they have to show best effort to apply. Is that right, Director Nigam?
Yes, so what we're saying is the first is the landlord provides a declaration form to the tenant. Second, in the declaration form, there will be language that the tenant was infected because of COVID-19 and whatever the other factors were. As long as the tenant signs that form and gives it to the landlord, then there is no late fees or anything. What we're also saying, within that form, there will be no judgment whether or not the tenant has applied for the rental assistance, because we know for a fact that tenants whom we have not been able to reach out to, and we know for a fact that those tenants have not applied for rental assistance. So what we are saying is two things. One is the landlord provides a declaration form to the tenant if they want to charge the late fees. The tenant signs that declaration form, gives it back to the tenant, but that there's no language in the declaration form that the tenant has applied for the rental assistance, because this is simply a temporary measure. If this measure will end on August 15th of next year, this is not on a permanent basis. So we are making sure that the tenants understand what the form is, a lot of tenants don't even know what their rights are. So we are making the process as easy as possible so that it's not a burden on the tenants, and they can, get on with whatever they are doing at this point. So which will help them in getting up and and making sure that the tenants understand, and also they have a path forward in terms of economic security. So what we don't want is to put another condition in that form per se that the tenants have applied for rental assistance. We want to make that form as easy as possible.
All right, we'll continue here. Councilmember Friedson, we'll come back to this.
Yeah, well, a couple things. Like I said, I have a different approach to this, and so I'll be talking that shortly. But a couple things. One, I just want clarification, because a penalty of perjury standard generally does not require any documentation at all. A penalty of, just to be clear, and I just want Ms. Wellens to confirm this, in every other document that I am aware of, in every other situation that I know of, including ones that I was responsible for at the state level, a penalty of perjury standard means there is a box to check on a form that says, under penalty of perjury, I attest to the fact that I have met the following standards. That's it. There is no proof of anything. There is no documentation of anything. So you're hearing two sides. They may not agree on this, but it sounds like that is a concern. I'm not sure there's understanding on one side that what a penalty of perjury issue is, and there's concern on the other side. It seems to me, at least from what we've heard, that it's hard to know what that means for people to understand even what a best effort is. If the concern is that 2/3 of folks who are eligible, who are getting evicted, which would mean that they are eligible for assistance, I would imagine, or at least overwhelmingly eligible, are not applying for assistance. It seems both folks here are suggesting that perhaps you just use the eligibility standards themselves, that's objective criteria, and say you meet the following standards. It's much easier to understand and much easier to prove. So I just wanted to clarify those two things. The objective standards of the eligibility, you wouldn't have to prove that you applied, because we know a lot of people haven't applied who are eligible. It would just be that you were eligible to apply. So you're the targeted group of folks who have actually been harmed economically by the standard. So I just wanted to point out, it seems like there's more consensus here than most. It sounds like we were discussing, number one, and number two, it seems like we were talking about a penalty of perjury standard that isn't, at least what I'm aware of, as a traditional penalty of perjury standard, which is to say you attest to it under penalty of perjury and we trust you. There is no verification process unless there's a lawsuit or there is an audit or some other action is taken after the fact.
Yeah, and I just say I agree with you. That's right. It is normally a checkbox. The difference being here, though, that before the late fee is applied, that you have to be able to check that box.
That's a notice requirement. Yes,
right.
I just to clarify, and the point that you just made that I forgot, I was meant to say, but I forgot to add, is what really is being discussed, I think, from DHCA is the notice requirement.
Right.
So you could create objective standards and a notice requirement with, and potentially address this. Again, I have a different approach, but I think, in listening to this, I just wanted to clarify those points.
Dean, so it was our intent to create objective standards relying on the existing objective standards of the rental assistance program with a little bit of what the CDC has used as well. So Christine has drafted it this way, for a particular reason. So Christine, can you, again, talk about that, and then how could we get a notification requirement added into this?
Right. Thank you, Mr. Chair. So, I think that part of the point of the CDC standard was to alleviate some of that burden of proof. I think that Councilmember Friedson is right that, you attest to something under a penalty of perjury, which is obviously, hopefully most people would take quite seriously. but it doesn't involve, okay, and here's my documentation to prove that. And I assume the CDC did that in part to alleviate some of the paperwork burden, not simply for themselves, but for landlords as well. But we could certainly, this could certainly be changed to, instead of best efforts, it could be changed to has submitted the application, or if following DHCA's advice, you don't want to have them to have to show that they submitted an application, could simply reiterate the qualifications that, that they've experienced financial hardship, had the gross household income below 50% of AMI, et cetera. And we could just spell those out. And if you wanted, instead of penalty of perjury, and I think this would go closer to the amendments that Councilmember Friedson will discuss, but it could be that you're showing some objective, documentation to show these elements, if that makes sense. So I mean, we could easily rewrite the amendment if you'd like to incorporate those elements.
So, Christine, like you were saying, if it's simply a statement under penalty of perjury that the tenant is eligible to receive assistance and has suffered COVID-19 related, losses, that's fine, as long as it doesn't say that the tenant has applied for rental assistance, because we know that there are several tenants who have not applied for rental assistance. They may not even know about rental assistance.
Okay, I want to ask you a question, Director Nigam. Why don't we want people to have to apply? Don't we want them to get rental assistance?
No, we're not saying that people should not apply. We want people to apply, but if the condition for waiving the late fees is that they have applied, we know for a fact that they have not applied. What they're certifying is they're eligible for the rental assistance. But why
would we want to facilitate people who are eligible for rental assistance but haven't applied? What is the tenant issue that would prevent them from applying that we want to protect?
I think if I could chime in, I think this is a protection for tenants, right? So you want the protection to be in place. We want them to apply. And I think if someone asserts their rights, if they're like, hey, I got charged a late fee, if they call Rosie and landlord tenant and say, I heard late fees were prohibited and I was charged a late fee and I'm behind, she would say yes. But then the second thing would be, I would assume, have you applied for rental assistance? Here's the link. You need to, we'd like you to do that. But you don't want to lose the right to have your late fees waived if you didn't apply for some reason. I think that's the point.
Because that tenant may not, well, first of all, you have to have missed more than one rent payment, I think, to be eligible for assistance, right? So there are people who might just have been late once or twice, but actually can pay their rent. And so we don't want to require them to apply for assistance that they aren't eligible. We don't really need to give them when they aren't really eligible for, I guess, right? Is that a group of people? I mean, is that what the concern is?
If they are eligible, if they're going to fill out this form, maybe the form should tell them they can apply, or they have the right to apply for rental assistance.
Right, I mean,
you could include information on rental assistance, which would be in both the landlord and the tenant's interest.
Yes.
So I think that is a pretty low standard. I do have a hypothetical. Based on the standard of attesting that you've made best efforts to obtain rental assistance, at a certain point, the rental assistance, we hope, will be spent. I mean, we want it to go faster, frankly, than it is. It's not going nearly as fast as what any of us would hope and would want. What's the standard then? If there's no money left in the account to ask somebody to apply for relief that doesn't exist in order to prevent a late fee from being charged, I mean, to me, that's where I think the standard is tough. That's why I think that you're hearing from both from DHCA and from the property owners that it'd be much easier to just objectively set the criteria and say, here's what the criteria is. It's both the same criteria for the same targeted group of folks who've been most impacted to prevent a late fee from being charged because they wouldn't be able to pay it anyway and shouldn't have to be racking up and putting them more adversely impacted by the pandemic. And from DHE, they shouldn't have to prove that they've applied because not everybody has applied. We know that 2/3 of folks who are being evicted haven't applied. That, raises the concern that you're not providing the targeted protection to the targeted group that you want.
All right. Nicola.
Sure, I can be brief. I mean, 2 points. I think we are talking about, someone who, maybe defining tenant in the bill as someone who meets the eligibility standards under the COVID rent relief program is one option, or alternatively, as Christina has mentioned, actually enumerating the specific qualifications. And just by one for clarification, I do want to say, I know we moved away from the application language, but I just want to quote the DC language is, the tenant or their authorized representative submitted an application for emergency rental assistance prior to or during the 60 days after receiving a rent. So they've used that standard. I know the conversation has shifted here to using the eligibility requirements under the COVID rent relief program, and I think there are benefits to doing that. But I thought it'd be important to share that kind of application language that DC uses.
Okay, so Christine, you can draft us something that's more consistent with what DHCA is saying, that there's be a notification requirement, certification of meeting the standards, but
yeah. So I guess my two questions would be, this is more towards, and maybe this will be discussed with Councilmember Friedson's amendments, but more towards whether it's going to be a declaration or if it's going to be a provision of, underlying documentation to prove the financial hardship. So that's one issue that I would just need to clear up in order to draft this properly. And then the other one, and this might be a question for DHCA, is, what would be the turnaround? How long does the landlord have to wait for the tenant to provide the application before the landlord's assuming, okay, this tenant's not responding, I'm just going to impose the late fee?
So, Christine, on your declaration form, we want this to be simply a declaration. It's not that they need to provide, the tenant needs to provide documentation. It's simply a declaration form.
Okay.
Now, in terms of the turnaround time, Rosie's with me.
If you sign the declaration and the landlord says, because I feel like if you declare it, maybe you should submit some kind of proof or something or some statement, and I think that's it. We can't.
Yeah, I mean,
Review everybody's form.
If you become aware of your rights 6 months after the late fee has been charged and it's within the defined period of time of the bill, which is only 9 months extra than a year, but 9 months past the 90 days on the, you get the right. So it either has to be taken off.
I don't want to be inundated with people who, I don't want it to be contingent upon what we say, whether they waive the late fee. That's what I'm saying. Off the bat. If you sign the form, then your right should kick in.
Right.
If they don't, if you're late, then you come to me.
and then
Depending on the rental relief application. I mean, you're taking the same class of people with the same objective standards, and you have a process for determining whether or not they're eligible. What is that standard? It should be the same. If we're going to use the same criteria, why don't we use the same standard?
That's what I'm saying. You talking about landlord tenant. We don't review those.
But Rosie, you just suggested that the tenant would submit that to the property owner, right?
Yeah. And so if the property owner doesn't comply with the law, then you come to me, but we shouldn't have to approve the form itself.
No, I'm suggesting two parallel tracks. I mean,
Okay.
and I'd be open. I'm going to change my position from the beginning, and I can only propose one part and not the second part of what I'm planning to propose. And, potentially if we could find consensus here, agree to, move forward potentially. So I'm a more productive part of this conversation than I intimated in the beginning. But if there's two parallel tracks, one track for the exact same population, for the exact same eligibility criteria, if that's the direction that we would be going in, whatever the standard is that they are showing or HHS and DHCA, to receive rental assistance, if they've already applied, they would already have that prepared and ready. You can make it exactly the same to make it as easy as possible. If they haven't applied and we want them to apply, having them have that ready so that they could get a notice that says, by the way, you're eligible for rental relief programs, please apply here, they would be ready to go. So I'm just raising the question of what is the standard that we're using to determine eligibility, that they meet those criteria. Is it penalty of perjury and an attestation before they get the money, or is it something else? It should just be the same. I think that's what.
Yeah. And I was trying to, I had the form, I read from the form earlier of what HHS is using, which does require you to describe, your loss. It's more than a checkbox, so that they do have which is different because they are giving out money. So it's slightly different than this, as opposed to preventing things from being charged or increased. But they do ask you to describe in written form when you apply your COVID loss situation. I do not, I don't think that is necessarily appropriate here. I think if they apply, they should do that. But in this, what we had talked about was an attestation that you had the loss under the criteria that Councilmember Ringer put on. You would check that box in that form. Then the second part we're talking about that is not in there now would need to be the notification requirement, which hopefully would encourage people to apply for rental assistance as well. And in Rosie's, landlord tenant is only hearing about it if there's a complaint that, hey, I filled out this form, I attested to the loss, but I'm being charged a late fee, and then she would get involved. It's all going to be complaint based anyway, and hopefully the information gets out there. But so I think it has to kind of be two different. I understand your desire to want to make it the exact same thing, but you would have to get HHS involved or DHCA involved in reviewing the written text of what your COVID loss was, which is what is currently required to apply for rental relief. And I don't think we want to do that here. I think we just want to have the landlord send a checkbox, is what I'm hearing from DHCA, and probably make it easier for everybody. So, so I think in that case, it would just be a form from the landlord, a notification requirement from the landlord. DHCA could hopefully produce that template, right? Is that correct? DHCA?
Yeah.
Okay, and so you'd send it, that would be available. They'd check it. That would be sent out to everybody. If at any point during the coverage period that form is completed and submitted, the late fees would need to be either rescinded if they've been charged, or returned if they've been paid, I would think. But I think that could be handled administratively. So, that would be my suggestion to try to do it.
Okay. Christine, are you clear on how to do that?
Rose, you have something to say?
I just had a question for clarity. When you sign, if this goes through and the form is signed, you can't charge the fee during the 9 months. Is that you can't charge it ever, or is it just deferred until after the bill expires?
No, you can't charge late fee that accrued during that year.
Yeah. So period. Yeah. After the 9 months, then you can start again charging late fee.
But it would be late fee for September 2022, not not before that.
That's all I want. I just wanted clarity on that one.
Christine, is that clear?
Yeah. Yes. Thank you, Councilmember Jawando. I think that you cleared up my original question, which was just that from the perspective of the landlord, I provide this notice to the tenant never responds. Where am I then? it sounds like they need to then wait until the expiration of this bill to actually then charge the late fee, assuming they never received that form back from the tenant. If that makes sense. So,
Well, I think,
yeah,
correct. I mean, that would probably make sense. It depends on the landlord. If you don't get the form back, I think under the way this is written, you could charge the late fee because you don't know if the person that needs COVID relief. And then but we're trying to avoid that problem because, if I were a landlord, I'd probably wait. I wouldn't charge a late fee. I'd wait. But I think you could, under the letter of this, the way would be drafted, you could charge the late fees until you receive the form. If someone calls Rosie and says, I thought I couldn't have to charge late fee, and they say, oh, I didn't get the form. If they then get the form and check it, that late fee would need to be rescinded or returned. It would be how it would operate, in the example that you're giving.
right. So yeah, I was just seeking and it doesn't necessarily have to be in the bill, but seeking that clarity of the landlord, I provide the notice to the tenant. Do I wait 48 hours for them to return it before I assess a late fee? Do I wait a week?
I don't think we should
I don't know.
that. I think it's just,
okay.
It depends on them. They can charge it until they know, that hopefully they won't, but it would be but they could have to potentially rescind it if the form is filled out.
Also, Mr. Joando, I'm sorry, if I may, we do have an uncodified provision of this bill indicating that the landlord is not required to return rent or return late fees have already been collected. So in this scenario, and you were mentioning that you might have to return a fee. So
I thought we said we didn't have to return them if they were collected prior to the enactment of this bill that previously collected late fees. So I thought that's how I read it. Maybe I misread it. I thought that was in relation to late fees that had been collected prior to the enactment of the bill.
let me go back to the bill.
I think that would be the intent. Otherwise, it would be a somewhat retroactive, application.
Right, and there is retroactive application here, and I think the idea was to somewhat limit that.
Right.
So, and it was a bit of a split the baby approach of saying, okay, this is what it currently states. The prohibition on late fees, it applies to any uncollected late fee for rent that became due on or after the date of the emergency, including rent that became due on or after the date of the emergency and before the effective date of this act, but does not require a landlord to refund to a tenant any payment received by the landlord prior to the effective date of this act. So that would include late fees that had, racked up over the emergency if the tenant's already paid them. So the landlord would not, the way we have it currently written, the landlord is not issuing any refunds.
Right. But what my point was, if they start collecting late fees after we pass the bill, and then that form comes in, they would have to give those back. That's what I'm saying, because the bill would have passed. Does that make sense? And I think that's consistent with what you just read.
Yes, that makes sense. Thank you.
All right. Do you have clear direction, Christine, for the amendment?
Yes.
Okay.
I'll support that amendment. I said originally that I was not going to, and then I'll adjust what I propose, excluding out the late fee, because I think that is largely moved it into something more similar to what I was suggesting.
Okay, without objection. Thank you. All right.
Mr. Reamer, I'm sorry, Mr. Chair, did you want to amend your motion or?
Yes, that's it.
Okay.
Yeah.
Okay, sorry.
I was amending my motion. And I believe the motion is without objection, right?
Correct. Based on what we just got to.
Yes, exactly. Consistent, and we'll ask you to send it around and just make sure, please, that it reflects what we were saying here. Okay. All right. Item 1, Councilmember Freeze.
Yeah, thank you. I have another amendment, and I appreciate the conversation that we just had. I think it reflects what I would prefer to do here with the broader bill, which is to target the protection and the relief to those we know have been hit the hardest and have been, financially impacted. I mean, what we know, unfortunately, is during COVID, certain people have been not impacted at all or impacted in a very limited way financially. We've all been impacted, emotionally and psychologically, and some, and too many of us with our health. But financially, this is disproportionately hit certain members of our community extremely hard, and many other members of our community, financially at least, not hard at all. And I think that we could have an approach like we did with the late fees, like we had unanimous support in order to do that. And I think we can go a little bit further, frankly, in that protection, to make sure that we're targeting this problem, which is a targeted problem, to the population that we know needs it, just like we do with the renter relief funds, just like we've now done with the late fee protections. So I have an amendment that I have proposed that would cap at 0% any increase in rent between November 15, 2021, which is when the original bill is set to expire, to August 15th of 2022, a year after the governor's declared emergency, for those who demonstrate that they've suffered a substantial loss of income and unable to make rent payments as a direct or indirect result of the COVID-19 pandemic. That would be Part D in the bill, and I sent around to colleagues an amendment. It's a two-part amendment. I'm not putting forward the amending lines 30 to 33, which relates to late fees when prohibited, since we already addressed that. So I'd like to put that forward. I think it is a balanced approach. I also think that it's a targeted approach for a targeted problem. I think that it addresses both the racial equity, social justice impact statement and the economic impact statements, both of which were part of this bill. If we know who has been hit economically and financially devastated by this pandemic, the other side of the pandemic, and the potential economic impacts and unintended consequences that going too broad in a solution, as well intended as might be, on a targeted problem could have long term, and the ripple effects that would create. I'm going to put that forward as an amendment. I just want to share with colleagues, I would be open to taking a similar approach on this as we just took with the late fees. So we put forward a standard. There wasn't a lot of time when this was added to the agenda. I had Yom Kippur on Thursday, so we put forward what we thought was the best way to put this forward. Apologize for the lateness in it coming forward, but I would be open to changing the proof standard, so to speak, to the same standard that we just approved on the late fee, that sets the objective criteria with an attestation standard and notice requirement. So with that, turn to colleagues, but I think this would be a more targeted approach to a targeted problem, and would allow us to go further to provide the type of support that we know certain members of our community desperately need.
Okay, so appreciate what your intent here. I guess a concern I have about this is that, first of all, I would be more inclined towards this if we had been at 0% for the whole sector and we're extending 0% for the sector. As I said at the outset, I thought we were thoughtful in allowing, the property owning community generally to get an inflationary increase to help grapple with the loss of rental income from those who aren't paying. And my understanding from market data is that actual rental increases have not exceeded that anyway. And so there really hasn't been a loss. There hasn't been a desire to increase beyond that, I guess. but what you're offering here, again, I think it's thoughtful, but my concern about it is that I think it potentially requires, I guess, litigation for folks to kind of resolve a dispute. And aren't the courts already completely overwhelmed? And so,
just to clarify, what
yeah,
I'm confused as to what would require.
well, I guess let me ask you. I mean, if I understand, you're saying so. Property owners.
I'm saying that this bill expires on November 15th that we currently have in place. The proposal before us is to extend it to everybody between November the 15th and August the 15th of 2022, which is a year after the expiration. That was after we extended the original bill as part of a compromise, instead of 30 days to 90 days. That was the original compromise. There's also then a 90-day notice requirement. So it's actually longer, than that in practice in terms of the relief that it provides to residents. It really doesn't allow for an increase until the 181st day, currently, where rent could be increased exceeding that number. What I'm suggesting is, we know that for some people there is almost no, if not no, financial impact at all. In fact, some people have financially benefited significantly during this pandemic. Unfortunately, there's been a massive increase in wealth in the country and in our county. But there are certain people who have been devastated financially by this pandemic. And so all I'm saying is, rather than having a hugely broad standard, which is a rent control standard, that's what this is, a rent control bill, and saying we have a rent control bill, but we're going to end it at a certain point, and I'm not sure if there'll be another extension or not, rather than focusing it on people who really don't need it at all. We would be focusing it on the very people we know have been impacted dramatically, devastated by this pandemic, and we would be going further than what we were doing for everybody, which seems more appropriate. To take a focused group of people who have been devastated by this pandemic and provide them with a higher level of relief, just like we do with rental assistance, just like we're trying to do with it. It would be the same type of approach we took with testing to target that. It would be the same type of approach we've taken with vaccines to target those. It would be the same type of approach we've taken in every single other area of the pandemic. This is one of the very few areas of the pandemic where we're providing blanket protections that have unintended consequences and not targeting it to the people who actually need it. So that's the suggestion here. I'm not sure where the litigation comes in. I would presume if somebody could litigate a cap at 2.6 or 1.7 or 1.4 or 0 or whatever the case may be. And I don't think that's going to be the case, because I think that most folks are not are not interested in going after people who have been harmed and devastated, aren't looking to put them out. But if our goal here is to protect the people who've been hit the hardest, prevent the type of evictions and other devastating impacts of displacement that this could have, I think it would be a better approach to take a more targeted way of doing this, and to go a little bit further, frankly, to provide that type of protection. So that's my proposal, my suggestion. I'd be open to a slightly different standard like we just did on the late fee protection, but it would be the same approach that we just took there. I think we should be taking on the broader rent side of this as well.
Thank you. Appreciate that. I'll turn it to Councilmember Juan, who's asked to speak. But again, my feeling is we know that a lot of people who are eligible for assistance are not filing. And we are, with this legislation, allowing for an inflationary increase across the whole sector. And while a targeted, even more targeted approach intuitively, seems reasonable, I think the concern would be a lot of people, since they're not filing for free money, aren't going to file to contest, an increase. And so we're creating a bit more, I don't want to say chaos, but we're basically cramming the burden down a little bit more, whereas with the bill as drafted, we're allowing for a broad, a broad-based increase, and I hope that in combination with rental assistance can help both the tenants and the building owners work through this. But Councilmember Jawanda.
Thank you, Mr. Reamer. And then I know we still got a couple of the advocates have their hands up after this. We see you, so thank you all. I think you stated something that I want to emphasize and then bring up another point. While I'm glad to see the 0%, if you remember the initial bill I proposed last summer was 0%. I would have liked to see this type of amendment then when we were in the throes of the crisis, but as opposed to allowing increases. But we did what we did, and it's been in place. And I think to Councilman Reamer's point, like it or not, that standard's been out there, and people kind of understand it now. That the general applicability is important because while it might sound good on paper to say, well, let's target it. What in reality, what's that's going to mean because of people's real life situations is that many are not going to be aware, have the wherewithal, understand they're right enough to contest it. And to the litigation point, even if they fill out the form, theoretically, they could be, there could be a claim that, you're not actually in this situation. And, while I don't think most landlords would do this, there could be, because this applies to all landlords of all sizes, there could be someone that takes someone to court and to contest that. And we certainly don't want that situation. And when you leave it at a broad standard, but allow a reasonable increase, I think you balance those interests. You give a protection to the majority of people, but you also allow for reasonable recovery from landlords, in addition to the rental assistance, which again goes directly to them, to the landlord. The other point I'd make is we don't know everyone's situation. The PHED recently put out a report that over 40% of Americans can't pull on $400 of cash in an emergency. We know that half of our renters in the county, where a third of our residents are renters, half of them are rent burdened, disproportionately, meaning they pay higher than 30% of their monthly income on rent already prior to pandemic, right? And disproportionately, those are people of color, Black and Latino residents. And so I just think you create chaos, I think is the right word. I think you create a situation where people aren't sure if they're right, not really don't assert it, and you create a confusion for folks. So I think we should allow. While I would prefer, I would love no increase. Again, that's what I proposed a year and a half ago. I think where we are now, keeping it at the cap of the guidelines for the additional year, in reality, really 9 months, is appropriate considering where we are. So just wanted to add those. And I know, Chair, if you're okay, I know Mr. Martinez and Mr. Whiteman want to say something as well.
You're muted.
You're on mute.
Thanks. I will turn first to Councilmember Friedson, who asked to speak, but as I pass the mic, I'll just say that this pandemic has certainly gone on far longer than I would have anticipated, or I did anticipate. And, there was a time when we all thought it would be over in 6 or 8 months, or at least we hoped it would. And certainly that has not turned out to be the case. So, Councilmember Friedson.
Yeah, appreciate it. And then I'll certainly allow you to turn it over to some of the stakeholders here. The only points I want to make is, first of all, I also wanted to have a more targeted approach when we originally put this bill forward, if you recall, and there wasn't interest in having a more targeted approach to that. I think we could have put this in place. It would have been a more acute solution. But we were in a crisis. It was hard to determine where we were and where we were headed, how long it would go. And I appreciate the fact that we are where we are, but we both share in the interests where we, perhaps wish that had been done a little bit differently. And, such is the legislative process for all of us, where we have to find consensus. Just wanted to note a couple things. This would allow for the very people that were being discussed to be protected. The question I think we have to ask is this idea of rent burden, which I agree with. I think that a lot of that has to do with broader economic factors like wage growth and others, which we need to do more in order to address, and the fact that we don't have enough housing supply. And I do have concerns with the impact that this could have on housing supply and on potential displacement, where landlords understandably could choose to not renew leases and start a new lease, and the new lease doesn't carry with it the same protection. And so there are ripple effects and there are unintended consequences that I think we have to try to balance and understand the impacts of what we're attempting to do in real life. I also think that when we talk about the rent burden broadly, I think the question we have to ask is whether or not rent control is the best approach to solve the issues that we're trying to solve. This is rent control. That's what this is. I mean, when you don't target the relief to the people who need it, who are most impacted, it's not an emergency measure to support emergency impacted individuals. It is a broad-based solution to implement rent control on admittedly a temporary basis. But that is the question that is before us here. I know we have philosophical differences of opinion on that. I respect those differences. I don't believe that rent control is an appropriate response. I don't think that it has worked where it has been attempted. I think it has severe unintended consequences, largely for those it's intended to help the most. So I just wanted to note that and appreciate being yielded the time. I'll yield back to the chair to turn over to the stakeholders.
All right. Yeah, it's an emergency measure. I mean, I think it's something that we all never contemplated having to be able to enact. And I think we're recognizing that the emergency has lasted far longer than we ever wanted to, and extending its timeline accordingly. Let's go to Ms. Whiteman, followed by Mr. Martinez, and then Councilmember Duando is asked to speak as well.
Great. Thank you, Councilmember. I think it's important to first note that this is a COVID relief bill, and so it's appropriate, as the county has done with everything else regarding to COVID, to really target relief to those who have been impacted. Everything that the council has done in terms of on the commercial side and then on the rental housing side has been targeting those who have been impacted by the crisis. So I think it's certainly appropriate to make sure, as is any other affordable housing program, targeted to those who need it. And consistent with what the council talked about earlier, I think it could be done through the objective needs or the eligibility standards of the COVID rent relief program, as discussed by the committee. Yeah, I think where you have litigation concerns is where there's clarity and ambiguity. And so either on the other amendment as originally drafted, what does best efforts mean? When it's open to interpretation, and when you have to go to courts to make it, when there's a dispute as to what that interpretation means, that's where you have litigation. So using an objective, clear standard, such as the eligibility standards of the COVID rent relief program, provides that clarity and certainly would mitigate against or reduce any issues regarding litigation. And I do think too that it's just, again, it strikes the right balance. We talked more about this at the hearing about what housing providers are experiencing, and that's and what tenants are experiencing. And so a targeted approach to those impacted by tenants provides the relief that's necessary to those that continue to be impacted by COVID, but also providing the relief to housing providers that have been impacted by 18 months of declining rent payments. So there's a broader issue about sustainability to maintain housing, sustainability to preserve housing. I do think there's a legitimate conversation to be had around broader policies around those who are rent burdened, beyond this bill, outside of this bill, and we're certainly interested and willing to continue to have those discussions. But today, I think the concern is really about those impacted by COVID and how the county could and should provide the relief that's necessary to that population, while also balancing the ability to make sure that we can continue to maintain safe and habitable housing in the county.
Thank you. Mr. Martinez.
Well, thank you, Chairman, for inviting CASA to the hearing today. We are appreciative of Councilmember Friedson's approach, but we do not in support of his amendment. We believe that the original bill is already enough of a compromise. We believe that keeping it to the voluntary guidelines of 1.4% cap for the entire county is something that is appropriate, and we feel like any extra due burden onto renters is unacceptable during this time. I know we talked a lot about a lot of the nuances about who should be eligible and what the eligibility criteria should be, but we're seeing on the ground in real time that individuals that are eligible not having the resources to navigate government and to be able to receive those resources. So I think any opportunity that we can make this easier for the folks that we do want to help in this emergency, I think we should push forward and continue to do.
All right. So again, I feel that we struck a difficult compromise last time, and you can stick to it. Councilmember Joanda.
Yeah, thank you. Just briefly, I wasn't going to go there. Councilmember Friedson invoked the larger debate. I'll just say briefly, we will have that conversation. I have a bill pending before the committee, 5220, to an anti-rent gouging bill to cap rents to the voluntary rent guidelines within transit, where the rents are the highest and where there's the greatest chance of displacement. The rental housing study done by our own planning department, who is not in favor generally of stabilization of proposals, prepared, by the way, by former developers and people who work for developers, think that rent stabilization and anti-rent gouging renter protections need to be a part of the mix. And so we'll have that discussion, and I think we should. But the reality here is, one, we don't know everyone's situation. Everyone has been impacted by COVID. I think that was said in a deeply personal, economic, professional way. Some homeowners in particular some have not been hit as hard. Renters have been disproportionately impacted. And because of literally the health proximity of being a renter in a multifamily property, for example, as one of the many ways, and the disproportionality of who rents, Black and Latino residents being the majority of renters. And so I don't think we want to assume or create an extra burden and think we know everyone's situation. The DHCA considers a 10% increase constructive eviction. So tantamount, the same as evicting somebody. If someone rent goes up from 1,000 to 1,100 in 1 year, that is considered by our housing department as to be constructive eviction. And so what we don't want to allow in a county that's over 1 million people is what will happen if we don't keep this as a broad protection. You will have hundreds, thousands of people who just don't get the protection and are put at risk for being out on the street. And I think in the middle of a pandemic, that's the last thing we want. And I think that's why, I think it is a good compromise. It's already a compromise position. And I think, with the late fees, I obviously was not 100% comfortable with that. I didn't introduce the bill that way. I would have, but I think we made a compromise there, which also has a means testing effect to it, which I think is another balancing factor. So I really feel strongly that we should, proceed as the bill is drafted. Thank you, Mr. Chairman.
All right. So we have an additional amendment. Councilmember Friedson, did you want to proceed with that? I think it's
going to, basically fail for lack of a second. So we can dispose of it if there's not support for it. I appreciate the conversation. I think it's a constructive conversation. Respect the differences of opinions here. I don't think we're that far off in what we're attempting to do here. I think there's a different approach to try to achieve the outcome, and respect where everybody's coming from. But I will, respectfully end the conversation there.
If you want to get it in the packet 2-1, I'm with you. I understand that I've done that before. I'm often on that side. So
no, I appreciate that. Yeah, I think if the packet could just reflect, we can vote on it or not vote on it. That's less important to me, but I think if the packet could reflect that this is a discussion point, or we can
Sure.
vote on it. You know, whatever you know, pleases the chair on that. But it would be helpful, I think, if it was in the packet for the full council's consideration, if there was interest of the full council to adjust the approach. I think we ought to at least have that conversation at full council, respectfully.
That sounds fine. Put it in the packet for the full council, the amendment. And, you know, I don't think you have to put you know, we haven't voted on it today, but I think it's clear where we stand. All right. Thank you. We have an underlying lead bill to send to our colleagues. So we'll now vote on the amended bill. Christine, is there anything else before we vote on the amended bill?
No, I don't believe so. Thank you, Mr. Chair.
All right. So show of hands for the amended bill. All right. And those opposed. All right. 2-1 on the amended bill.
The reason stated earlier, if
Okay.
that packet could reflect that. Thank you.
Fine. Okay. Fortunately, that's all we have for the day. I mean, for the morning.
For the morning.
We'll be back
I won't be back.
We'll be for a long slog this afternoon.
Sorry, Councilor, if I may, just a brief point as the Fed moves forward and as the council deliberates. I think one point that hasn't been discussed in this, maybe just to raise, is that there's a 90-day notice requirement. So as we talk about some of the deadlines in this bill, or if it continues to be amended, just know that, you know, when you have no increases through August 15th, that means, and no notices, that you're talking about it going beyond the August 15th date. So it's not something that ends on August 15th, because then you can own the first notice is going on August 16th. So I think that's just, as we look at the timelines, it's important to consider that, or to factor in the 90-day notice period of a rent increase, because the bill is currently discussed by the Fed committee. We're talking about August 15th for the rent increases as well as the notices. So I think that's something to take into consideration as discussions move forward.
Okay. Thank you for raising that. We'll take a look at that and we'll bring that to full council. All right. Thanks, everybody.
Thank you.
Bye-bye.
Thank you. Take care, everyone.